7-0-0-0. State versus Richard D. Wallace. Can I have parties announced for the record for the state? For the defense?
Michael Collins, attorney for defendant, present and ready.
And are you Mr. Wallace?
Yes, sir.
All right, let's start off with the plea paperwork and with the judgment.
Welcome to Courtroom Chronicles, where real drama unfolds under oath. Today's case is a powder keg of second chances, spiraling addiction, and one final plea for redemption. Richard D. Wallace stands before the court once again, but this time it's not just his freedom on the line. It's his future, his family, and his very identity. We'll unravel the shocking pattern behind his repeated violations, dissect the legal turning points, and examine whether the court's decision was justice or mercy. Stay with us because just when you think you've heard it all, this case takes a twist. Let's break it down.
The offense for which you were convicted is going to be assault, intentionally or reckless breathing to stop circulation, family violence with a previous family violence conviction. Is there any objection from either party to changing the current judgment to that to that offense?
Here's our first legal checkpoint. The judge is correcting the conviction language from choking/strangulation to reckless assault interfering with circulation with a prior conviction. That's a big distinction. While both are serious, this shift can affect sentencing outcomes and how the charge is viewed by future parole boards. So here's a question for you. Should a paperwork correction like this matter if the outcome is similar? Or is the language a critical part of justice? Comment below.
Punishment in place of confinement. It's going to be corrected to show that it's 6 years TDCJID and a fine of $1,500, imprisonment, institutional division. Any objection, state?
No, no.
Defense, any objection?
No, no.
Mr. Wallace, any objection? Any objection to the court signing the judgment non pro tunc as with those corrections? State? Defense?
No, no.
The court then is signing the order, and if either party needs a copy, the clerk will prepare a copy so that you all may have it. Next, we're going to proceed. Now the court is going to proceed with the motions to revoke. Mr. Wallace, did you review the document entitled Motion to Revoke Community Supervision, First Amended Motion to Revoke Community Supervision, and Second Amended Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Richard D. Wallace who was placed on community supervision in 2018 CR 7000 for the offense of assault, intentionally or reckless breathing, circulation, family with a previous conviction on December 17, 2018 for a term of 7 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor, on the second amendment motion to revoke. Violating Commission number 1, on or about the 20th day of June 2024.
Now we hit the heart of the probation issue. Wallace admits again to a violation. Possession of a controlled substance. This isn't just another mistake, it's a relapse that the court has seen before. Remember, the legal stakes here go beyond a fine or a warning. A true plea opens the door for full revocation of his community supervision. 6 years in TDCJ could be waiting just on the other side of this admission.
Stand by pleading true to violation of condition number 1. The court could find it true, grant the motion, find you guilty, and sentence you up to 6 years in prison.
Yes, ma'am.
And up to a $1,500 fine.
Yes, Your Honor.
Counsel, for your client.
Yes, sir.
And state.
Sure.
Knowing this, do you still wish to plead true to violation of condition number 1?
Sure.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Or, however, the state is TIC taking consideration 3 different cases. County Court 14 case number 722471, and that's a theft case, and then also a possession of controlled substance case as 2024 PF 04139, which we have cut true to. And that's a possession case, and another possession case of 2024 PF 04140. And Your Honor, the state is recommending revocation.
All right. And defense, what are you requesting?
Your Honor, my client was put on at the time.
Defense counsel makes a strategic pivot, humanizing Wallace by detailing his long journey through Safe P outpatient programs and a solid 19-month clean stretch. But then, he meets Janelle and spirals. This is more than a timeline, this is a tug-of-war between rehabilitation and relapse. Here's the debate. Should the system show leniency for someone who proved capable of change, even if they ultimately failed? Sound off in the comments.
Days, Your Honor, completing that on December 13th, 2019. Beginning on December 13th, 2019, and ending on August 18th, 2020, my client did Safe P outpatient aftercare, Your Honor. If you look at the motion to revoke, Your Honor, or the court summary, he was testing clean for a long time, Your Honor. He tested clean from December 17th, 2019 until July 23rd, 21. We did have one positive during that time period, Your Honor, 19 months. Right after that, my client, he hooked up with some lady that he knew or met. She was heavily into drugs. He relapsed, Your Honor. And as you see on the testing after that, it went downhill, Your Honor. Started testing positive, failed to submit, all those kind of things until it
Was her name Eve?
What's her name?
Janelle?
All right, I always say, was her name Eve because, you know.
Oh, the temptation.
Yes. That's we
Not this
blame
time.
women
Not this time, Your Honor.
for leading us astray.
No, he realizes he made a mistake in being with her and relapsing. Your Honor. What we're asking for, Your Honor, he realizes he has a problem here with the drugs, Your Honor. He'd like, Safe-P did him good, Your Honor. He came out, he was doing fine. He'd like another chance. I believe in talking to the probation officer, there is another, like a relapse program or something like that they have through Safe-P or something similar to that. And he's more than willing to want to get into that program and get himself some help, Your Honor. He still, of course, has until December of 25 at this point if the court does not extend his probation. But of course, if the court extends it, he would have still a lot more time on probation.
All right, probation. What is probation's recommendation? All right. So is there anything you wish to say, Mr. Wallace?
Yes, ma'am, Judge.
All right, you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Richard D. Wallace.
All right, what would you like to say?
Just want to say, Judge, that come before you today that when I got out of prison, I did 9.5 years of a 10-year sentence. And that was 2017 when I was released. When I was released, I only stayed out. I came out with 6 months parole. And I came back to jail in 4 months. When I came back in 4 months, that's when I picked up that charge.
Wallace's testimony is raw. He confesses to relapsing, getting kicked out, and then spiraling into drug use and new charges. What stands out isn't just the fall, it's how quickly he slipped after doing everything right. His story is a painful reminder that recovery isn't linear. But does accountability demand prison at this point, or another shot at treatment? Is he being sincere, or just saying what the court wants to hear?
I met somebody. I got with somebody as soon as I got out. I got with a good woman, and she helped me save money. I was working, I was doing everything, but I happened to relapse. And then from there.
Well, let's back up a minute. The good woman you were with.
Yes, ma'am.
Is that the same woman who led you astray?
No.
So you preferred someone to lead you astray over to the good woman who was there for you always.
Yes, ma'am.
All right, we can continue.
And, well, she tried to tell me to stop doing the drugs, but I was already too hooked on drugs that's all I really cared about. And she got tired of it. She kicked me out. I went back to my mom's. I hooked up with this girl. And then from there, I just drowned myself in drugs. And after that, Your Honor, I relapsed. And I was already, when I was going to probation, I was already in process. When I was coming out dirty, my probation officer had told me, well, I'm waiting for the courts to send me back on what they're going to do with you. So on that same day, that was a Wednesday, and 2 days later, I had a warrant put out for me. And well, that same day, I get a phone call. Well, that same day, I get locked up. I come to jail. I post bond because I was trying to get out before the MTR. So I get out. But this woman that I was with, Your Honor, and I'm just telling you the truth, man, it was over drugs. I didn't take her to the dope possible score. So we went to
Oh, no, here's the thing. Let me just tell you, the state didn't go over any of those allegations. They weighed them. So the only thing we're dealing with is...
Things escalate fast. Wallace tries to explain a domestic accusation, one the state didn't even pursue. The judge shuts it down. We're not dealing with that today. This is a crucial moment. The court is laser focused on the single probation violation, drugs. By cutting out the noise, the judge prevents a courtroom circus and keeps the case on track. But for Wallace, this means the chance to explain his full story just slammed shut.
2 days later, when I posted bond Monday, my probation calls me and asks me, she's like, how were you released if you're supposed to turn yourself in to safety because you were going to go back? I said, ma'am, I never turned myself in, picked up another charge. So from there, she had said, well, let me call you back. Well, from then, my phone died out and I never heard nothing. So I just left it like that. So I stayed on the run for a year. And that's just the truth, Your Honor. The only thing is that I'm asking you is that my life and my future is in your hands, you know? And all I'm asking is a chance. I'm coming to you for help so you could help me so I could successfully complete this probation. And I'm asking you that it's you that has the authority, the control, and the power, that either you could help me, send me back to prison, or you can release me. And if it's in your will to put me in an outpatient or rehab, and I'm willing to do. And whatever the stipulations that you want to give me, I'm willing to do. And I leave it to you, Your Honor. And just for the record, I just didn't feel that with the VA, I tried to explain this, but I didn't have the chance. So I said, you know what, I'll just put my life into your hands and I'll let you decide.
Okay. Any questions, defense? State, any questions? All right.
Could I have those printed out pages, please?
All right, the court is finding violation of condition number 1 true. I want you to know that I always listen, and people who come before me, I see every person who comes before me as a human being. I don't see people as criminals. That is why normally I will call people the accused, because that's what they are. I try to stay away from calling people defendants and giving anybody, be it for the state or the defense, certain labels, because I think once you start giving those labels, then your mind switches to a different place. So I see you as an accused person. And I understand that there's been help for you. And the reason, when you're sent to SafeP and other places, I know that once you successfully complete SafeP, they place you in outpatient treatment. And when those things are done, you've been given the tools to stay clean and sober. And those tools are calling your sponsor.
The judge's ruling is balanced, even empathetic. She acknowledges Wallace's humanity, his struggle, and the tools he's been given. But there's a pivotal message here. Addiction can't be an endless excuse. He's not being punished for hurting others. He's being held accountable for refusing to help himself. In the system, it's done trying. The gavel's about to drop.
Charges, they are not hurting other people, they're hurting themselves. I will usually try to work with you and get you to an inpatient treatment. And if people don't want it, they don't want it. We can say, I tried, the state tried, the council tried. All right. Your case is something that's completely different. So I'm going to find number 1 true, take in consideration county court cause number 1470. I'm going to give you credit for the time that was successfully completed in inpatient treatment, not the aftercare portion, just inpatient at SafeP. And of course, give you credit for any time served, which the court must do. There's a $1,500 fine. Time and money will run concurrent. I'm going to revoke you. I'll suggest the therapeutic community. You'll have to sign up for it. I have no jurisdiction to have you placed in that program. That program doesn't increase the length of time that you're in custody, but hopefully it will help you with your addictions. When you're released from prison, if you can't find a place for inpatient treatment, if you come back here, I will call around to make sure you get in place at an inpatient treatment facility. Does anyone wish to speak to length?
Yes, Judge. I mean, considering that it was suggested Saturday before or yesterday, the state's requested 6 years.
All right, defense.
Your Honor, in light of my client having gone through inpatient programs, outpatient programs, aftercare programs, Your Honor, and coming to the court and explaining that he still has problems with drugs, being very forthright to the court, we'd ask that the sentence be closer to 2 years, Your Honor.
All right. The court will sentence you to 6 years in prison. Is there anything else with regards from sentencing for either side? All right. Did you review the state you may be excused? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is not a plea bargain agreement. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion.
6 years. That's the final sentence. The court recognized Wallace's completed inpatient treatment, but determined it wasn't enough. The judge offered therapeutic options in prison, but made it clear her jurisdiction ends here. This ruling underscores a core legal truth. The court can give you the tools, but it can't make you use them. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay sharp, stay informed, and stay out of trouble.
All credit that he has been spent in custody.
Yes, you'll receive credit for the time that you've been in custody and also credit for any time an inpatient